Hey everybody, it's Paul from Cary Estate Planning back with another video as part of our 2020 video challenge. And today I wanted to talk about selling the home after a spouse has passed. And so in North Carolina, most married couples will own real property together, but there's always a potential for assets that were owned prior to the marriage or inherited property. And so determining the real estate rights of the surviving spouse really depends on researching the actual titling of real property of the surviving or of the deceased spouse prior to their passing. And so generally that's going to fall in a couple different ownership classes. First and most common is what we call tenancy by the entirities, and that's what would be considered marital ownership. And that's generally when two spouses are married and they acquire real property together. That sort of real estate holding carries with it rights of survivorship. So if something happens and one of the spouses passes, the surviving spouse gets immediate vested title as a 100% owner of that asset. And so that will allow the surviving spouse to sell that home relatively soon after the death of the deceased spouse. And what I mean by relatively is we usually have to have the death certificate proving that the spouse has passed. But there generally isn't the need to do a notice to creditors. There isn't the need to even file the will. It's a lot more expedited process in marketing title. And again, that's going to be the most common form of ownership between spouses when it comes to real estate, especially the personal residence or any investment properties. When it comes to heirs property or tenant in common property, the way that the property will pass will be dependent on the estate plan of the deceased spouse. And that's because there usually isn't going to be rights of survivorship included in that sort of ownership. It will be driven by the will of the deceased spouse or the lack of a will or intestacy. And so the will usually, when there's a married couple, will give everything between the spouses, what we call mirror will. But in the absence of a will, generally the surviving spouse has default elective rights in real property, especially the personal residence, in the event that they're not the named beneficiary of the estate. So what that looks like for you is going to be very unique, and it really depends on where you live and how you took title and the way things were situated when the spouse passed. If you need assistance in looking into that particular issue or getting ready to sell a home after the passing of a deceased spouse, we'd be happy to help. We jump on phone calls or in-person meetings quite often to talk about surviving spouse rights and what that should look like, especially for real property. You can click our link below and you can get on our calendar for a strategy session at your convenience. This is Paul from Cary Estate Planning.